Chairman Schweikert. I want to start by saying welcome and to offer my sincere congratulations to you on becoming our new subcommittee chairman. I'm looking forward to working with you. I'm hopeful that we can find common ground and develop meaningful solutions to our nation's important environmental challenges. And I agree, improving transparency and public access, especially to federally funded research at the EPA or at any Federal agency, is an important objective and one that I fully support. And although there may be disagreements among the subcommittee members about various actions that the EPA may be considering, I am confident that we all support increased transparency. Unfortunately, it appears that the language in the bill we are discussing today, called the Secret Science Reform Act, may actually prohibit EPA from increasing transparency. And I hope that this is an attempt to prevent or impede the EPA from promulgating regulations and performing its congressionally mandated priority objective of protecting human health and the environment. If implemented as written, this bill would actually prevent the EPA from using the best available science to inform its regulatory actions. The EPA relies on thousands of peer-reviewed articles as part of their scientific review, and under this proposal, if for any reason all of the scientific and technical information associated with those articles was not publicly available, the EPA would have to proceed as if those studies did not exist. And that is not in the best interests of the American people, who are our constituents. It is also not clear whether this proposal is retroactive. If so, then the legislation would essentially nullify all the progress we have made to date to improve the quality of the air our children, and in fact all of our constituents, breathe and the water that they drink. I am also concerned about the potential negative impacts that the bill could have on the scientific community. Researchers and organizations may be hesitant to conduct EPA-funded research if they are required to disclose protected information like health records. Historically, researchers have been able to assure individuals participating in their studies that their personal information is safe, and that helps attract participants. Now, last year, this committee took the unusual action of issuing a subpoena to acquire data that the EPA relied on when developing air quality regulations. This data, the basis of the Harvard 6 studies and the American Cancer Society study, contains personal health records of hundreds of thousands of Americans. And I presume that this is an example of the so-called secret science that inspired this bill. But contrary to the assertion that the science behind those studies is secret, in fact, the legal owners of the data sets, Harvard University and the American Cancer Society, do allow legitimate researchers access to this information, and they have procedures in place to protect it. So it is interesting, this committee did spend a significant amount of time scrutinizing healthcare.gov and claiming that the website actually puts personal health records at risk. Frankly, I am a bit surprised that my colleagues do not now recognize the importance of protecting studies that actually do contain personal health information. But perhaps what is more troubling about this proposal, and I look forward to discussing it, is that it ignores the good work already done by this committee. In 2010, this committee reauthorized the America Competes Act, which requires the Office of Science and Technology Policy, or OSTP, to issue guidance to all Federal agencies on the development of clear and coordinated policies to increase access to federally funded published research and digital scientific data. And it is my understanding that the EPA is currently in the process of developing policies pursuant to that guidance. This bill also seems to be inconsistent with the data and public access provisions included in the majority's First Act. Although there are some open questions about specific provisions of the First Act, the bill takes the more appropriate government-wide approach and requires consultation and input from the scientific and stakeholder community. It is worth having a real discussion, and again, we look forward to that, about how we can improve transparency and data access across the Federal Government. Additionally, as we have discussed, I hope we are able to have another hearing on this issue. I strongly encourage the participation of the EPA so that the agency has an opportunity to appear before the committee and provide on the record their analysis about the provisions of this bill. It would be logical, and I suggest Mr. Chairman, that we hold such a hearing in conjunction with our colleagues on the Research and Technology Subcommittee, because they are also examining this issue very closely. Mr. Chairman, I truly hope we can work together to find a way to improve public access to federally funded research in a manner that does not compromise the EPA's mission to protect human health and the environment. Thank you again, and welcome to the committee, Mr. Chairman, and I yield back the balance of my time.